Hello, and welcome to this episode of Legally Norette, Legally Raven-haired Legal. Today, we are reading from Civil Procedure, 5th edition by Joseph Glanning. I just want to say, I think that's how you pronounce it correctly. Professor Glanning is amazing. He actually, in the beginning of the book, tells you that you can email him and ask him questions, and he responded, I believe, within a matter of hours, definitely less than a day. So it's a great resource for someone who writes the book to actually be available for questions. So that's great. So now we're talking about seeking the home field advantage, challenges to personal jurisdiction. Okay, so introduction. Surely one of the most fundamental principles of civil procedure is that the courts of a state may not exercise judicial power over a defendant unless that defendant has, in one way or another, submitted to the jurisdiction of the courts of that state. A century of case law has given some specificity to this requirement. As Chapter 1 indicates, defendants may be subject to jurisdiction under the due process analysis on the basis of domicile in a state, in-state service of process, consent to jurisdiction, continuous or substantial in-state contracts, or as a result of minimum contacts with the forum state that give rise to a particular case of action. So these are all the ways that defendants may be subject to jurisdiction under due process. It is not always clear when a plaintiff sues a defendant in a particular state whether one of these bases for personal jurisdiction is met. Suppose, for example, that Wolf, a North Carolina novelist, gives a newspaper interview in North Carolina in which he disparages Hemingway's writing abilities. Hemingway sues Wolf in Oregon for libel. When Wolf is served with the complaint, he may be unsure whether the Oregon court has the right to exercise jurisdiction over him. For example, he may not know whether the newspaper that interviewed him is circulated in Oregon or whether Hemingway has suffered any injury in Oregon as a result of the alleged libel. If Wolf has no other connection with Oregon, he may well conclude that the courts of Oregon have no right to order him to appear and defend the suit in Oregon. This chapter explores the options available to a defendant like Wolf to present his objection to the exercise of personal jurisdiction over him by the courts of another state. Generally, these options involve a challenge either in the court in which the original action is brought, the rendering state, or in another state where enforcement of this original judgment is sought, the enforcing state. Challenging jurisdiction in the rendering state, direct attack. The defendant's first option is to appear in the original action at the beginning of the suit and object to the court's exercise of jurisdiction over her. I object. For example, Wolf may decide to appear in the Oregon court and ask the court to dismiss the action for lack of personal jurisdiction. The procedure for doing this varies from state to state. In some states, the defendant who objects to the jurisdiction files a special appearance, in quotation marks, special appearance. Under a special appearance, the defendant is allowed to appear before the court at the beginning of the action for the sole purpose of challenging its power to exercise personal jurisdiction over her. If the defendant is careful to appear specially, she may litigate the jurisdictional question without submitting to jurisdiction by the very act of appearing before the court. Let's read that again. If the defendant is careful to appear specially, she may litigate the jurisdictional question without submitting to jurisdiction by the very act of appearing in court. So she can litigate the jurisdictional question without submitting to the jurisdiction by the very act of appearing before the court. However, the court who files a special appearance must exercise extreme care not to raise any other issue. If she raises any objection or argument that the court can construe as a defense on the merits, the court may conclude that she has waived her personal jurisdictional objection. So she can appear and she needs to only talk about one thing. You don't have jurisdiction over me. If she brings up any other stuff, which is very difficult sometimes for people like me, I don't want to talk about women in general, but I know that I personally sometimes have a hard time not bringing other things into an argument. Okay. For example, in is it Copeland, the Saul Lerner Co. The defendant enter a special appearance to object to the court's jurisdiction and also move to strike the complaint for vagueness. The court held that this hapless defendant, by raising the vagueness issue, had addressed an issue going to the merits and thereby has submitted to the court's jurisdiction. The pitfalls of making successful special appearance are discussed in Casad and Richmond. A growing number of states have abandoned the common law special appearance device in favor of the more liberal approach to challenging personal jurisdiction used in federal courts. Under the federal rules, as under the special appearance, a defendant may appear before answering to the merits of the complaint and object to personal jurisdiction. However, under the federal rules approach, the defendant may also raise other objections at the same time without waiving the objection to personal jurisdiction. For example, under federal, I don't know how to read cases yet. A defendant may move to dismiss for lack of personal jurisdiction and at the same time for failure to state a claim upon which relief can be granted. The second objection clearly goes to the merits of the suit. If a defendant did this in a state that adheres to the older special appearance rule, the court would hold that she had waived her objection to personal jurisdiction by bringing up matters going to the merits of the case. And here is a footnote. Under federal R-Civ P12B, I need to learn how to read that. The defendant may also raise the jurisdictional objection to her question to the complaint. If she did not file a pre-answer motion, the crucial thing is to raise it immediately, either in the answer or a pre-answer motion. See Chapter 18, for example, in which the objection was raised in the answer. See the defendant's answer to the Shulansky case, Infra P604. Thus, the federal courts under Rule 12B and in the numerous state courts with similar rules, the defendant has a little more flexibility in raising the objection and is less likely to be tripped up by the procedural technicalities of doing so. But under either approach, the objection to jurisdiction must be raised immediately or it is lost. A defendant who answers on the merits and later concludes that personal jurisdiction is lacking will have waived the objection by failing to raise it at the outset. So if you have an issue with jurisdiction, that needs to be the first thing you talk about. If you argue something else first, as to the merit of the lawsuit, you automatically have lost your right to question personal jurisdiction. We'll read more about that in Chapter 18. If Wolf properly raises his objection in the rendering court under either the special appearance approach or the federal rules approach, whichever applies in this state, the court will hold a hearing on the issue. If the court concludes that there is no basis to exercise jurisdiction over Wolf, it will dismiss the suit. However, if the court concludes that it does have power to exercise jurisdiction over him, at least for the claim asserted by Hemingway, it will proceed with the case. In most states, the defendant who challenges jurisdiction at the beginning of the suit and loses may proceed to defend the merits of the suit without waiving her objection to the court's jurisdictional ruling. If she loses the suit on the merits, she may appeal to an appellate court in the rendering state, claiming that the trial court conclusion that it had personal jurisdiction was wrong. Let me read that again. In most states, the defendant who challenges jurisdiction at the beginning of the suit and loses may proceed to defend the merits of the suit without waiving her objection to the court's jurisdictional ruling. If she loses the suit on the merits, she may appeal to an appellate court in the rendering state, claiming that the trial court conclusion that it had personal jurisdiction was wrong. So basically, this is saying that a defendant challenges jurisdiction and the court says, no, we have jurisdiction. So she says, okay, fine, I'll go ahead through the lawsuit because I have to. However, I'm still objecting to the fact that you have jurisdiction. So in the end, if she loses the case, she can appeal in that same rendering state to say, hey, I don't believe the trial court said that they had personal jurisdiction, but I think they were wrong. So Friedenthal, Kane, and Miller, 196, 4th edition, 205. This scenario is hardly palatable to Wolf, of course, since it requires him to do exactly what he believes he should not have to do, defend the action in a state that allegedly lacks personal jurisdiction over him. However, it at least leaves him an avenue to correct the trial judge's mistake and to avoid being bound by a decision rendered by a court that lacks jurisdiction to render it. In some state court system, a defendant whose challenge to the rendering court's jurisdiction is rejected may take an immediate appeal to the appropriate appellate court in this case. This has a great advantage for the defendant. If the appellate court concludes that she is not subject to jurisdiction in the action, it will order it dismissed, and the defendant will avoid litigating the case in that court. In Worldwide Volkswagen v. Woodson, 444 U.S. 286, 1980, for example, several defendants sought a writ of prohibition from the Oklahoma Supreme Court before trial to bar the trial judge from subjecting them to jurisdiction in Oklahoma. A few states even require a defendant to take, what is this? Interlocutory review, presumably on the rationale that dismissal of the case, if jurisdiction is lacking, will save everyone the useless exercise of a trial destined to be nullified on appeal. Other states, however, do not allow interlocutory, I need to make sure I pronounce that right, appeal on personal jurisdiction. And the federal courts generally do not allow them either. Although the argument for allowing such appeals seems strong, especially to the defendant, there is also a strong counter argument. If the appellate court affirms the trial court's conclusion that the defendant is subject to jurisdiction, the case will go back to the trial court for further proceedings after a lengthy delay to process the appeal. Challenging jurisdiction in the enforcing court, collateral attack. A section option for the defendant who objects to personal jurisdiction is to ignore the original suit entirely. If Wolf is truly convinced that Oregon lacks personal jurisdiction over him, he may view the suit as mere harassment, an ineffective proceeding that can give rise to no binding judgment and that can therefore be ignored with impunity. If the Oregon court lacks personal jurisdiction over Wolf, any judgment it enters in Hemingway's suit will be unenforceable anyway. If that's true, why bother to respond at all? Procedurally, it is true that Wolf has the right not to appear in Oregon if the Oregon suit lacks jurisdiction over him for the claim asserted in the suit. However, this course poses a serious risk. If Wolf fails to appear at all in Oregon, either to object to personal jurisdiction or to defend on the merits of the libel claim, the court will probably enter a default judgment for Hemingway. That is a judgment that Wolf is liable to Hemingway on the claims asserted in the complaint. If that judgment is enforceable, Wolf will have lost his suit without ever having a chance to defend on the merits. The usual method of enforcing money judgments against out-of-state defendants is for the plaintiff to take her judgment against the defendant to a state where the defendant lives or has property and seek a court order from the court of that state authorizing the sheriff to sell the defendant's assets to satisfy the judgment. Hemingway, for example, may take his Oregon judgment to North Carolina where Wolf lives and ask the court to authorize the judicial sale of Wolf's house to pay for the judgment. However, the North Carolina court will not directly enforce the Oregon judgment. Hemingway must first obtain recognition of the Oregon judgment called domesticating the judgment, like finding a home for a wild animal, in one of two ways. The traditional procedure is to file a new action on the judgment in the enforcing state, North Carolina in this case, seeking a judgment on the judgment. A good many states now provide an alternative statutory procedure for domesticating foreign judgments. Let's go down to 2. The word foreign in this context refers to a judgment of another state, not to another country. The judgment creditor, Hemingway in our example, simply files a certified copy of the Oregon judgment in the North Carolina court, eliminating the need to file a new suit there. Let's go down to the footnote 3. Most such statutes are based on a model act, the Uniform Enforcement of Foreign Judgments Act, 1964 Revised Act, 13 ULA 155, 2002. There is also a federal statute authorizing registration of federal judgments in other federal districts. There is also a federal statute authorizing registration of federal judgments in other federal districts. Okay. In states that have such a procedure, the judgment creditor may either file a traditional action on the judgment or use the statutory filing procedure. The full faith and credit clause of the United States Constitution requires the courts of each state to honor the judgment of other states by entering judgments upon them and allowing out-of-state creditors like Hemingway to use court process to collect them. Once Hemingway obtains a judgment on the judgment or under a registration statute registers the judgment in the enforcing state, he may invoke North Carolina procedures for collecting it, including placing liens on Wolf's assets in the state, forcing sale of those assets, or initiating court hearings to determine Wolf's ability to pay. There is, however, an important exception to a state's duty to give full faith and credit to a judgment of another state. The enforcing court may always inquire as to whether the rendering state had jurisdiction in the original action and refuse enforcement if it did not. See Pennoyer v. Neff. For example, if the North Carolina court concludes after a hearing on the jurisdiction issue that the Oregon court had jurisdiction over Wolf, the North Carolina court must enforce the Oregon default judgment by entering a North Carolina judgment on the original judgment and making its procedures for execution. For the grim sounding terms refer to the various court procedures available for obtaining satisfaction of a judgment by seizure and sale of the defendant's assets. See generally Friedenthal, Kane, and Miller. Okay. Execution of judgments available to Hemingway. However, if the North Carolina court concludes that the Oregon court did not have jurisdiction over Wolf, it will refuse to honor the Oregon judgment, and Hemingway would not be able to levy on Wolf's property in North Carolina. Thus, if Wolf ignores the Oregon proceeding, he will still have an opportunity to protect his property from being sold on execution in North Carolina. Even if a default judgment is rendered in the original Oregon lawsuit, Wolf may oppose enforcement of that judgment by asserting in the North Carolina enforcement action that the Oregon court lacked personal jurisdiction over him. If Hemingway brings suit to obtain judgment on the original judgment, Wolf can raise the objection as a defense to the enforcement suit. If Hemingway files the judgment directly, Wolf can raise an objection by a motion asking the court not to enforce the judgment. See Uniform Enforcement of Foreign Judgments. Okay, now. This is referred to as a collateral attack on the judgment because the defendant challenges the original court's jurisdiction in the enforcement action rather than directly in the original suit. Collateral attack is clearly more convenient for Wolf because he does not have to go to Oregon, something that from his point of view, he shouldn't have to do. It also allows him to litigate the jurisdictional issue in his home state. While the issue of whether the Oregon court had jurisdiction over Wolf will theoretically be the same in either state, it is at least possible that a North Carolina court will be more sympathetic to Wolf's objection than the Oregon court would be. However, this strategy poses a great risk for Wolf. The full faith and credit clause allows Wolf to question the rendering court's jurisdiction, but not reopen the merits of the underlying libel action. If the North Carolina court concludes that Oregon had jurisdiction over Wolf, it will automatically enforce the Oregon default judgment. If Wolf's original conclusion that the Oregon court lacks jurisdiction is wrong, and most conclusions in this area are only educated guesses, the default judgment will be valid and enforceable in Oregon and any other state. The idea is that a defendant has the right to stay away if a court lacks jurisdiction, but not if it has jurisdiction. In the latter situation, the defendant is deemed to have waived her defense on the merits of failing to appear. That is a very considerable price to pay to avoid contesting the jurisdictional issue in the plaintiff's chosen forum. All this is complex enough, but one further wrinkle is also important. It is true that the full faith and credit clause allows defendants such as Wolf to resist enforcement of another state's judgment on the ground that the rendering state never obtained personal jurisdiction over them. But there is an exception to this rule as well. A defendant may not challenge personal jurisdiction in the enforcement action if she has already done so in the original action. Suppose, for example, that Wolf had appeared in the Oregon action and moved to dismiss for lack of personal jurisdiction. If the motion was denied and Wolf then defaulted on the merits, he could not renew his challenge to jurisdiction in an enforcement action in North Carolina because he had already litigated and lost on that issue. Once is enough. The rules of collateral estoppel provide that a party who has fully litigated an issue in one action may not relitigate it in another. See chapter 27. Thus, Wolf gets his choice to raise the objection in one court or the other, but not to resurrect it after it has been fully litigated and decided. While the explanation of these principles is lengthy, their application is fairly straightforward. The following examples should help. See also figure 3.1 below, which illustrates the various possibilities. Please assume that all cases are brought in state court unless example specifies otherwise. Also assume that the special appearance rule applies in Mississippi. Until 1982, Mississippi practice required defendants to raise objections to personal jurisdiction by special appearance. Mississippi now follows the federal rule models, which allows defendants to raise the objection by a pre-answer motion to dismiss or in their answer to the complaint. Assume and analyzing the examples that the special appearance rule still applies. Okay, so here we have defendant's response to the original suit. Defendant appears, defends on merits, and loses. Action in the rendering court enters judgment for the plaintiff. Action in the enforcing court must enforce the rendering court's judgment, even if the defendant challenges the rendering court's jurisdiction. Defendant has waived his objection because it had already appeared in the original suit and lost. Defendant makes special appearance or 12B2 motion, which you don't have to make a special appearance, but it is raise an objection to personal jurisdiction in a pre-answer motion. Court agrees it lacks jurisdiction. The action in the rendering court that doesn't have jurisdiction in most cases dismisses the action for lack of jurisdiction, and some may order proper service to cure a jurisdictional defect. I don't know what that means. I have to find out. If original suit is dismissed, there will be no judgment to enforce. However, plaintiff may file a new suit in a court that has jurisdiction over the defendant. Okay. Defendant makes special appearance or does the pre-answer motion, court oppose jurisdiction that defendant defaults, enters, and then defendant defaults, enters judgment for the plaintiff. Must enforce judgment because defendant already litigated the rendering court's jurisdiction and lost. Defendant loses on objection to jurisdiction, defends action on the merit, loses and appeals. In most states, appeal late court may review decision that jurisdiction was improper. A few may treat defense on merit as a waiver of the jurisdictional objection. If jurisdiction upheld on appeal or objection waived by defense on merit, must enforce the rendering court's judgment. So if the jurisdiction upheld the appeal, so they're saying that they have jurisdiction, or objection is waived by defense, or the defendant waives the objection on merits, they must enforce the rendering court's judgment. Defendant defaults, contest jurisdiction in enforcing court. Enters default judgment for plaintiff unless lack of jurisdiction is clear from the complaint. Enforcing court may decide whether rendering court has jurisdiction. If it finds it did not, it refuses enforcement. If it finds it did, it must enforce the judgment. Lastly, defendant defaults, denies liability on merits in the enforcing court, enters default judgment for plaintiff unless lack of jurisdiction is clear from the complaint, and then enforces the judgment. Full faith and credit clause precludes reexamination of merits which are settled by default. So the defendant defaulted, denies liability on merits in the enforcing court. Well, the enforcing court said, no, you still default. The plaintiff gets the judgment unless lack of jurisdiction is clear from the complaint. Unless they didn't have jurisdiction in the first place, they will enforce the judgment. The full faith and credit clause precludes reexamination of merits which were settled in the default. So they can't reexamine based on the merits. Only reexamination happened based on the jurisdiction. Challenges to personal jurisdiction, some common scenarios, examples. All right, so here we have it, and that is chapter 3 of Examples and Explanations Civil Procedure, 5th edition.